So what we're going to talk about now is some different ways, some more innovative ways that it may be possible. To ensure that business is held to account in supply chain context, and as a result of claims that can emanate from greenwashing, and also on behalf of investors in companies that have committed themselves to certain responsibilities in terms of human rights and the environment. So we've got 3 speakers here, and we've decided to reverse the order a bit just at the last minute. Audrey's agreed to go first, and just to tell you about our 3 speakers. Audrey is the chair of National Resource Governance Institute's Advisory Council and executive director of the Centre for Research on Multinational Corporations, SOMO. So a lot of us have had dealings with SOMO and Audrey over the years. Next we'll have, after Audrey, Giza Lukowski, who is a solicitor in our international group litigation team here at Lee Day, and she is interested in holding private and public entities to account, and is working currently on one of the largest consumer actions that we're involved in the English courts, or relating to car emissions technology. So there's some quite interesting possibilities that arise from that. And last but not least, Mariel Hodgson-Teal, who's one of our partners, again in the International Group Litigation Department. And she specialises in large-scale collective proceedings, primarily acting for consumers, but she's a font of all knowledge in our firm when it comes to commercial matters, and has certainly taught me everything I know in that area. So, Audrey, if we just kick off with you.
Sure. Thanks, Richard.
And we'll have questions at the end, and I think we'll have plenty of time for that.
Great, thank you, and thanks for inviting me to speak. So, I'm going to talk about 2 areas where SOMO, which is the Centre for Research on Multinational Corporations, 2 areas where we're currently looking at litigation opportunities in the context of the energy transition. But before I do that, I wanted to say a few words about framing that will pick up on what Rosa Maria said, and because any litigation or any remedy action that we work on happens in this context. So the energy transition, the economic model that underpins the energy transition is exactly the same economic model that underpinned the fossil fuel sector and the whole fossil fuel era, with only one exception. That exception is that if you're an oil and gas company, you enjoyed rents, and rents are what you get when you can extract what you do not own from the ground, oil and gas or coal, and you're able to make a huge amount more money off it, even if it's volatile. But the fact that renewable companies cannot do that explains why companies like Shell and BP backpedal away from the renewable side of their business, or what they pretended to be the renewable side of their business, because you will never be able to make that kind of profit as a renewable company. And this is a big feature of what is happening in the context of the energy transition. But the energy transition itself, using the same economic model, and I'm going to speak particularly about Europe because Europe plays a particular role here, is highly corporate driven. The concepts of maximize shareholder value and growth at all costs underpin almost all actions that are being done in the context of the energy transition. And this is part of what is driving the abuses that other colleagues have mentioned. And one clear example is, if you look at Europe's energy transition, one of the biggest pillars of that is electric vehicles. So European Union politicians and UK politicians, to some degree, would be very happy if we were all driving around in our shiny electric vehicles. Great big success for energy transition, moving to electric vehicles. Ignoring the massive unsustainable consumption of Europeans, and I don't mean billionaires in Europe, I mean the people in this room, myself included. Europe's consumption relative to the rest of the world, unless you're looking at China or other parts of the global north like the US, is massively disproportionate. And we want the resources of other countries, as we have always had them, to fuel our lifestyles. And that's a huge obstacle to any kind of just energy transition. What's also overlooked is what's been discussed today, which is the tens of thousands of people whose lives are being, for the electric vehicle industry, for solar panels, for wind turbines as well, people whose lives are being upturned by the scramble for critical minerals and the competition that Europe, feeling it's late to the game, is in with China and the US. A competition it's losing, but that's by the by. It is desperately, through trade law, incentives and subsidies, trying to prop up industries and give them public money to turn into private profit so that they can go and chase minerals and allow, enable and drive the kind of abuses that are being reported with the extraction of graphite, lithium, cobalt, etc. This is all fueled by and supported by European politicians who are desperate for their industries to be successful. Because they're afraid of China, and this is where one of the litigation opportunities will come in, there's an integration of mine to electric vehicle. I'm going to come back to that in a minute. But one thing I would say that is very important for SOMO and for many, many civil society organizations in framing the energy transition and justice in the energy transition is to recognize that, and I'll again speak about Europe, Europe's energy transition is a colonial project. It's not neo-colonial because there's nothing new about it. It's Europe constantly seeing other parts of the world, mostly in the global south, as places where multinationals originating in the global north and China, but we'll leave China out for the time being, can go extract things. So as I said earlier, we can sustain our standard of living, our way of living. And that colonial model, which is being perpetuated economically, is something that increasingly there is huge anger and activism about bringing it forward, talking about decolonizing processes, bringing a just energy transition, not to tweaking around the edges of what exists, but actually transforming what exists. And that's influencing how a lot of allies in civil society that SOMO works with see all of this work. So it affects what strategic litigation, what kind of cases we will get involved with, and how we will frame those, particularly in public communications, because we do not want to see anything as endorsing the current model if you just make it a little bit nicer. Which would bring me to ESG. ESG, I don't know how anybody else feels about ESG, but manifest nonsense would be the polite way of putting it. We work a lot on ESG, primarily because it is clear that companies increasingly use ESG to mean not the environmental, social and governance factors, the impacts that they have. They mean how those things affect their bottom line. So if you talk to some companies, the ESG concern they have about climate change is how much climate change is going to harm their business, not how much their business is harming the climate. So ESG gets wrapped up with an awful lot of fig leaves, greenwashing, etc. So I said I'd talk about two particular cases, two particular issues which are related to this. One area where SOMO is looking at whether there is potential to take effective litigation or other legal action is in relation to the integration of mining and electric vehicle manufacture, because the electric vehicle manufacturers are the ones driving huge demand and putting massive pressure, both for consumers to buy what they produce, but also putting huge pressure for greater and greater and greater extraction, as Rosa Maria said. So how do you not just go after the mining companies, which are often not well-known names, but go after the big companies that are pushing this and profiting from it? And one thing that we've observed, and we don't have any answer to this, I'm just saying this is where our work is going, and be interested to hear if anybody has any thoughts, is this much stronger connection now across the supply chain, which those of you who've worked in supply chains will know the hardest thing is when the harm is happening in place A, and then it goes through country B and C and ends up with product in country D. You have a really difficult time taking litigation against the company that's selling the product in country D over what happened in country A. But because of the fear of China, and China has the greatest control over processing of most critical minerals, because of that fear, there is now setting up of gigafactories and factories to do processing and get the supply chain not to have to run through China. So one case that SOMO is working on at the moment is an Australian mining company, Sierra Resources, mining graphite in Mozambique, and we're working with our partners in Mozambique on this. That company has been given money by a number of financial actors in Europe and the US government and by the US government to set up an anode factory to process the graphite in the United States, precisely to avoid having to go through China. Tesla has publicly gone on the record and saying it's sourcing its graphite or its anode battery components from there. So Tesla is now completely linked by its own admission to the mine site in Mozambique. That doesn't usually happen when you're looking at supply chain cases. And part of the reason it's happening is they don't want to be dependent on China, and part of the reason is an illusion that this means that the supply chain will be better, and that's not the case. So what we're looking at now is all of the big vehicle manufacturers who are buying into battery companies so that they know that they can get the battery components for their electric vehicles, and they know where those battery components are coming from. Actually opens up opportunities to go after them about what they know, but there are big questions about what kind of research and investigations best put together the argument that will be useful for strategic litigation. So that's just a question I toss out there. The second and final thing I wanted to mention is another area where we're hopeful that strategic litigation will come in around greenwashing and challenges, what we see as, well, not what we see, what many see as major challenges to a just energy transition, and this is carbon offsetting or biodiversity offsetting. So for those of you who aren't so familiar with it, carbon offsetting is basically a product. Don't think of it as doing something nice for the environment. It's a product. There's an industry. It's a $2 billion industry and growing rapidly. That's global north companies who have set up to produce a product called carbon credits or carbon offsets to sell to other largely global north companies so they can not reduce their carbon, but they can offset their carbon. The projects that these companies and this industry puts together are large land-based projects covering things like forest or peatland. And their basic theory or the basic proposal that they put forward is that the local people, often indigenous people or marginalized people, because the majority of these are in global south, these projects, they are harming the environment and causing climate change by grazing their livestock or gathering firewood. We will stop them doing that, create credits and sell them to Shell or BP or various airlines. So that's the industry, it's the industry model. This industry is completely unregulated, massively profitable, and nobody whose livelihoods are affected by these massive projects gets even a tiny fraction of the profit that's being made, much of it pushed through, based on SOMA's research, tax havens and secrecy jurisdictions, so nobody knows how much money individual companies are making. But the companies are global north companies exploiting contexts in global south countries, exactly the same model, to create something that you can sell to big global north companies so they don't have to do so much about climate change. The thing I want to mention, and the strategic litigation opportunity, is not so much against those companies, it's these companies are propped up by social and environmental auditors. All of them are audited under, most of them under a scheme connected to something called Verra. I won't go into those details. But the social and environmental industry is also a big industry, also completely, unlike financial auditors, completely unregulated. And they rubber stamp or green stamp these projects. And then that is what's held up as the defense of carbon offsetting, both in terms of its carbon, that's the carbon that's offset, but also in terms of its human rights impacts. And they're able to sell these carbon credits based on these audited carbon credits. The companies that produce them can sell them at higher amounts if you can show, for example, that you help women and women's rights. So you can just take women's rights away from being a human rights issue, package it up, commodify it, and it throws 30 cents on the dollar on what you can sell. So women's rights, just slightly more profitable. These auditing companies are the things that we would like to tackle. And we've done some research in the Netherlands to see if that's possible. And it looks like it is on two grounds. And this is important not just for carbon offsetting. Those of you who know the due diligence legislation in Europe will know that what's being baked into the due diligence legislation is if you've got certification or social auditing, it's a defense against being accused of not having acted with due diligence. So this matters for many industries. But in the Netherlands, we have, with a group of law students, identified that there are two categories of people who could take legal action against social auditors if they have offices or are registered in the Netherlands, which some of them are. One is consumers in the Netherlands can take individual action, or potentially, which is harder in the Netherlands than the UK, a group action against the social auditors because they have misleadingly purchased something that they believed was beneficial or benign or supported human rights and climate change, and it turned out that it's demonstrably not doing that. And obviously you have to have the research that underpins that, but there is no shortage of that research. The other category is workers who are affected in carbon offset, or sorry, workers who are affected in carbon offsetting is what we're looking at. But in any sector where a social auditor has given a clean bill of health to the enterprise, to the clothing factory, the offsetting project, if an auditor has given a green light to that and published a report saying there's no problems here, it's all shiny and nice, and there were serious abuses of workers' rights, which again, in our research, we have identified very serious abuses of workers' rights, that there is the potential to take in the Netherlands legal action with and on behalf of the workers whose rights are affected. So those two avenues are open, both under what's called a duty of care, well, what is a duty of care, sorry, but also a duty of care that is related in the Netherlands to the expertise that is brought to bear by the auditors. So if they're shown not to have acted in line with their expertise and not to have identified problems they ought to have identified, then that opens possible avenues for litigation for those two categories. So that's the other interesting area we're looking at. But I realise I've probably overshot my time, so I'm going to stop there.
Really interesting thoughts there, Audrey, which we'll come back to, I'm sure, in a while. I just turned over to Giza now.
My talk actually fits very nicely with what we've just heard from Audrey, because I was going to talk about how we can use consumer protection legislation in the UK to tackle greenwashing. Because I think, as we're kind of all aware, obviously UK consumers are increasingly conscious of just the choices that they are making, which leads to companies making more green claims. And I think there have been estimates by, for example, the Competition and Markets Authority that about 40% of green claims amount to greenwashing. There isn't currently a definition and statute of what greenwashing is, but we can tackle greenwashing if we're looking at consumer protection legislation, which is what I was going to talk about. So I was going to just give a brief overview of some of the legislative tools that we have, then talk about some other avenues that are available to consumers, touch upon the emissions cases, and then just think about what's next. So as Richard kind of has said, just by way of background, I work on one of the emissions cases where we're pursuing the car manufacturers. Specifically, I work on the Mercedes case for, amongst other breaches of consumer protection legislation, because we are alleging that consumers were misled by claims as to the emission standards and how great a diesel vehicle was as opposed to a petrol vehicle. The law that is governed by is the Consumer Protection from Unfair Trading Regulations, which is derived from EU legislation. So it would exist the same way in other European countries. And then there's also the Consumer Rights Act of 2015 in the UK. And I think the way that I see this all fit in with what we've kind of talked about today is certainly carbon offsetting, because I think especially with carbon offsetting, that has a direct impact on UK consumers being told that a product is better than it is for the environment by the use of offsetting. And often, and I think that links quite nicely with what we heard about earlier and what Audrey also touched upon, it's just the climate colonialism that often underpins offsetting schemes. So I think if you look at satellite images of where offsetting schemes are located, often they are in protected area of indigenous peoples in like the Amazon and other areas of the world. But it is quite difficult to have a clear nexus of these claims that, as Audrey touched upon, are really unregulated, and the whole carbon markets is quite unregulated, and to create a clear nexus between the claims that, we've offset all the carbon, this is now carbon neutral driving, it's sustainable driving that you do over there, that you can do here in the UK, because people have been potentially misplaced in the area that they have been living in for generations. So yeah, just a very brief overview of CPIT, and I know that there's quite a lot of lawyers in this room, so you're quite familiar with it. But as I said, it's derived from EU law. There's a route for public enforcement, and then there's also civil redress since 2014, so whereby consumers can take direct action themselves. So just like a very brief overview is that there is a general ban on unfair commercial practices, and then there's a few more things such as misleading action or misleading omissions are banned, as well as aggressive practices by businesses. There also is an outright ban on some commercial practices when they're deemed to be so particularly unfair that they could never that they could never be fair to a consumer. So kind of what is in scope is that firstly it has to be a commercial practice that is within scope, which means there needs to be a business that is advertising something toward a consumer. Then it needs to be an unfair banned practice. As I said, there's a list of some practices that are deemed so unfair that they will always fall within the definition. So for example, that would be something like I pretend my product is scarce to drive the price up when in reality it isn't actually scarce. And then the unfair practice also has to cause or be likely to cause the average consumer to take some either enter into a contract or maybe like alter their to take some transactional decision about that product. And for that to happen, there either needs to be a misleading action, a misleading omission by the trader. They need to have engaged in aggressive practice, which would be something like coercing someone to take a commercial decision, or it needs to be against the general prohibition, which means that it would fall short of professional diligence that would be that could be expected from that trader. And also it would materially distort the consumer's choice. So what's quite important to see put is the concept of the average consumer. So if we're talking about products, particularly in like the greenwashing context, so products that are aimed at consumers that maybe are thinking about the choices that they're making and that they're trying to be making more sustainable choices, the threshold that can be expected of these consumers would be higher. Just go to my next slide. I was just going to briefly touch on the two ways that CPUT can be enforced. So there's the public enforcement route, which means it's enforced by either the Trading Standards Services in England, Wales, and Scotland, or the Department of Enterprise in Northern Ireland. The Competition and Markets Authority also have some small enforcement powers, and basically they can fine companies if they breach the general prohibition, and there's also a small sentencing powers if it concerns officers of a company that can be sentenced to up to 2 years of imprisonment. There is a defense to that, which is if the company or the trader has acted with due diligence. So that potentially could be quite difficult, because that acting with due diligence could mean that if I am a trader and I'm relying on information that I have received from someone else, and I have undertaken all my due diligence, and it's reasonable that I rely on that assumption, and then I take that assumption and advertise my product, it would be quite difficult for me to be in breach of the general prohibition. So I think that is quite relevant to potentially the offsetting schemes where like it's third kind of like companies that are completely separate, and if I have to undertake all my due diligence, there might be a world in which it's reasonable for me to rely upon, maybe not, but the nexus becomes a little bit more difficult. And the limitation for that is 3 years. Then since 2014, we've also had civil redress of CPUT. So that just means that consumers directly can take action, which is one of the causes of action that we rely upon in the emissions cases. Just kind of what you need to bring such a case is that there needs to be a business to consumer contract. So we need to quite clearly establish that the consumer has either entered into a contract or made some kind of payment based on either a misleading action by the trader or an aggressive practice by the trader. And the limitation for that is 6 years. So it's a little bit longer. And the interesting thing with the civil redress avenue of CPUT is the damages route, because it's prescribed in statute, and it ranges from 25% of the original purchase price of whatever the product is to potentially 100%. So complete recovery. That hasn't really been tested in the courts yet. So it's kind of a little bit TBC as to how that actually plays out in practice and what you need to prove for the different brackets. Then I was just going to very briefly touch on other avenues. So just especially as it concerns consumers. So the Advertising Standards Authority enforces advertising codes. They can't levy fines, but reputational damage, I think, is quite important to a lot of these companies. And increasingly, the ASA has been looking at green claims, and the ASA as well as the Competition Markets Authority have been publishing guidance on green claims and how to avoid green claims. And there's been like an uptick in complaints to these authorities, to both of these regulators. And then I was just going to talk very briefly about the emissions cases. So as I've said originally, and as Richard kind of said, we're bringing claims against car manufacturers and also their authorised dealers that sold vehicles or leased vehicles to UK consumers on the basis of these diesel vehicles being better for the environment than certain petrol vehicles. So one of the causes of action that we are pursuing is claims against these companies for CPUT. And so, sorry, I went too far. So one of the things that I think is interesting about that, and we also kind of briefly touched upon that in some of the other discussions, is with especially vehicles now, and now that we're moving toward electrification, I think we are likely to see quite a lot more of claims that driving can be sustainable, and I think we are already seeing that. So I think there's really like a chance to think about how potentially tackle those kind of like supply chain issues, like the mining of certain minerals that you do need for the electrification that is being pushed in driving already, that I think we are trying to see, that we are seeing in flying as well, and how UK consumers and like consumers that care about those kind of issues and how their rights are impacted by that as well, but also how the legislation that protects them can be utilized to tackle issues that are further down the supply chain and abuses that happen elsewhere. I just want to say or basically touch upon the two hurdles that I kind of talked about earlier. The first is reliance, so that the consumer needs to have been influenced by whatever the misleading action is. So in the example of sustainable driving, for example, it sometimes I think it can be, especially in the greenwashing context, it can be quite difficult to prove that this greenwashing, whatever the greenwashing is actually the one thing that led the consumer to take the choice that they did take. And then the other thing that I think is relevant here is just the defense that is available to companies where they rely on information supplied by another person and they have undertaken all their due diligence. So I think that is maybe now easier with what Audrey talked about, that like kind of China is falling out of the supply chain. But I think if there's a lot of steps and sometimes it's quite hidden how, for example, these offsetting schemes and like the mining impacts those consumers. I think that's all I wanted to say.
I'm sure we want to talk to you and Audrey afterwards about what remedies might be available under these various routes that you've mentioned, whether they constitute an effective deterrent and whether they would make a viable case apart from, in the kind of big emissions types cases that you're involved in. But we'll come back to that afterwards. We'll move on to Muriel.
Great, thank you very much. I have got a bit of a whistle-stop tour through some of the different things that shareholders can do to hold corporates to account. I'm going to try and cover two particular sort of legal routes that we've been thinking about at Lead Day and that we're seeing increasingly come to the fore, which is derivative actions, which is a particular procedure under UK company law, where shareholders can bring claims in relation to sort of corporate activity, and then shareholder claims against companies, which would be slightly different. But before I talk about those, I wanted to give a bit of background to this kind of area. My colleague Giza has already talked about why companies are increasingly saying that they're green, that they're sustainable, that they're responsible. And it's something where consumers increasingly have buying power over, to make green decisions. But it's not just something that we see in the kind of products that we're buying as consumers. It's also coming up in a financial context. It's our savings, it's our pensions, it's investments. It's statements that banks, pension funds, investment funds, and corporates that are listed on the stock exchange are increasingly telling us they're doing the right thing. They're considering how they're sustainable, their supply chain is all handled in a responsible way. And that means as those kind of companies make more of those statements, we as consumers in a way have more power, and there's more to hold them to account to. And it opens up different avenues for challenging the behaviour of these companies. And over the last few years, we're seeing an increasing trend of these companies being held to account, and helped not least by some of the changing regulatory landscape and what regulators are saying. Companies have to give additional disclosures relating to climate change if they meet certain thresholds. So what tools do we have to address this from the kind of shareholder or investor perspective? Everything that I'm going to talk about is relevant for UK companies, so it's all UK law. And a lot of it's mainly relevant for listed companies, but hopefully that will be clear as I sort of go through. And as I mentioned, there's these two tools to talk about. Too many pages here. Derivative actions. So, and I appreciate there's a lot of lawyers in the room, so apologies for anybody who's already very familiar with this, but a derivative action is essentially a procedure in UK company law where a shareholder can step into the shoes of the company to bring claims on behalf of the company against a controlling entity, and that's quite often against the directors. And it's essentially, it's a mechanism that exists for circumstances where harm has been caused to a company which would not otherwise be remedied because those in control of the company are not going to bring claims against themselves. So if directors have been doing something dodgy in the way they're running a company, they are not going to, at a board meeting of the company, decide to sue themselves. So shareholders can apply to court to step into the shoes of the company. And if they do that, a company can be then joined as the claimant, and the claim proceeds against the controlling entity, be it directors or whoever else. And there can be remedies obtained for the company. So whether that is, if it's damages, it would be damages for the company and the shareholder would only have an indirect benefit, or if it's a declaration or injunction, it would be preventing those in control of the company from continuing acting the way they are. And because it's so often directors that these kind of claims are brought against, I've put up here about the key directors' duties that we're seeing come up in the context of this kind of litigation. Directors have a number of duties to act number of duties towards a company and towards its shareholders set out in the Companies Act. I think the most relevant are section 171, 172 and 174. Section 171 is a duty for a director to act within their powers. And crucially, that means a director has to act in accordance with the company's constitution, but it also has to act in accordance with any associated articles, resolutions, or agreements, basically anything that makes up the company's rules and how it is governed. And they can only exercise their powers for the purposes for which they've been conferred. Section 172 is the principle that a director must act in a way that's most likely to promote the success of the company. And 174 is that they must exercise reasonable skill, care and diligence. These claims are quite difficult to bring. There's essentially a two-stage procedure, and the first stage is getting the court to let you step into the shoes of the company as the shareholder, and then you can go forward from there. But the first stage is quite a high bar. You need to persuade the court that you've got a prima facie case, so you've got a reasonable argument, even from the beginning before you've had, your disclosure or anything like that. You need to show that an independent board of directors acting objectively and in the interest of the company would choose to bring a claim. So that brings in factors like the cost of pursuing a claim. Is it really proportionate? Is the benefit that you can get from bringing this litigation something which is really going to benefit the company? And so it brings in all kinds of related factors as to whether a claim can go ahead. There's a question of whether the company has properly authorised the act or omission being complained of, whether the shareholders seeking to bring the claim are acting in good faith, and whether the company has already decided not to pursue a claim. And this brings me to, I wanted to talk about two recent examples that we've seen in the courts this year, where these kind of procedures in the context of kind of climate change litigation have been tested. one of which I think quite a few people might already be aware of, the Client Earth litigation against Shell's board of directors. But I also wanted to talk about another Magawi against USS. So starting with Magawi, this is a claim that Lee Day acted in. It was a claim against, or on behalf of, a claim relating to the UK's largest defined benefit pension scheme. It's the pension scheme for the university sector in the UK. And there had been ongoing disputes between the pension scheme members and the pension scheme trustee that was managing the scheme about how it would be managed, what benefits people would have under the scheme, what contributions they would make, but also about how the pension assets were invested in fossil fuels and other non-sustainable things. So Lee Day acted for 2 pension scheme members seeking permission to bring claims on behalf of the pension scheme corporate trustee that managed the pension against the directors of that company. The pension scheme trustee, in its sort of materials that were put out to pension members, said a lot about having a sustainability plan, complying with net zero, doing things right in terms of climate change. But then when you look at the underlying holdings, there were fossil fuel companies, Russian oil and gas was in there, Shell was in there, BP was in there. So it was a question of were they really doing what they said they were doing, and were they really meeting appropriate standards? And that was one, there were several different sort of aspects to the claim, but that was one of the allegations that the pension members were making, was that there had been a failure to come up with an adequate plan to divest fossil fuels. And this is, I think, something you were saying, Audrey, that sort of struck me. It was in order to make these kind of claims work, and what we were doing here is arguing that continuing to invest in fossil fuel related companies is financially a bad decision. So you end up arguing about the company's bottom line rather than the impact necessarily that the company's activities are having on the environment around you. But I think that isn't to say it's not still a useful tool for attacking these kind of the policies and the new projects and decisions made by corporates. So it's one thing as part of a wider picture of tools that we've got. Unfortunately, the claimants didn't get permission to go ahead and bring this claim. The claims, first of all, were not given permission to go ahead on procedural grounds. But also the judge held that there was no prima facie case of breach or loss. And this is where it's really difficult in the context of, or for these kind of claims to prove, well, first of all, the English courts are quite reluctant to set out what a director's duty is in the context of climate change. They don't want to impose a specific standard. They're keen to emphasize that it's up to a company to decide how to conduct its business in its own interests, and then establishing that there's a breach of that duty. It is a very high bar, and that's something I'm going to talk about in the context of the next case I wanted to mention, which is Client Earth against Shell. You might have heard already quite a bit about this. It got quite a lot of news coverage at the time. Client Earth bought 27 shares in Shell to allow it to act on behalf of, or to seek permission to step into the shoes of the company to bring claims against directors, arguing, among other things, that Shell's current energy transition plan would not allow the company to reach net zero by 2050, which the company had previously committed to. It was argued that Shell's failure to keep up with the energy transition would endanger the company's commercial viability and therefore breach its Companies Act duties. So again, focusing on the company's bottom line, but using that as a way of attacking the decisions that directors are making. There were a few stages to this. First of all, they had a decision on paper about whether they could get permission, and then it was taken to an oral hearing. And we had a judgment in July this year, where the court held that Client Earth did not have a prima facie case. And in particular, the court said that Shell, as a large company, has a lot of different factors to balance. The court does not want to interfere with commercial decisions central to the running of business. It's for directors to decide in good faith how to promote the success of the company. And they also said a number of other things in that judgment. But from those two cases, if I can just sort of draw out from there where I think that leaves us and where things might go. First of all, I think as the climate emergency becomes more and more clear, and as governments take more and more action, and we see, public policy changes, regulatory changes, the extent of apparent financial risk for companies may become more stark, and that might make it easier to make this kind of binary point that actually this is a breach of a director's duty in going forward with a new project of a company, for instance. So that's one thing to think about, is how the environment changing might make this a more useful tool. But another to think about is, I think, as companies are increasingly saying, we are going to do X, Y, Z in order to continue investing in it or continue behaving in a sustainable way, or we are going to meet net zero, or we are going to do things, the extent to which companies bind themselves to behave in a certain way, if it becomes part of a company's, or if directors effectively limit their powers by saying the company will, going forward, act in a certain way, and if that's recorded in a resolution or if that is reflected in a company's articles or anything like that, whether that will give a way forward for these kind of claims to say, actually, directors don't have the power to do certain new projects that are exploitative of the environment and not sustainable, and therefore they are breaching their duties, and there's a clearer case. So two things to think about in the context of those kind of claims. And then secondly, I wanted to talk about shareholder claims against companies, and where potentially we're seeing that develop. So this is rather than stepping into the shoes of a company to sue the controllers of the company, shareholders suing the company that they hold shares in themselves. There's a few different ways that these kind of claims can be framed. We're primarily looking at listed UK companies, so companies listed on the London Stock Exchange. The Financial Services and Markets Act has kind of two ways that you can go about this, depending on what the statement is that's been made by a company to the market, whether it's in a prospectus or another sort of official publication to the market. I'm not going to go into too much detail about the legal basis for these claims, but this was something that I saw reported, and completely appreciate that. I think this might illustrate the irrelevance of the ESG term quite neatly, but this is just an example of claims that have been brought under the basis of this Financial Services and Markets Act law that I mentioned, where shareholders bring claims against the company, where there's been misleading statements or omissions in prospectuses or other publications to the market. These are the ones that we've seen in the last few years. A lot of them are governance decisions, and that's internal company governance decisions. It's not really ESG in the sense that people kind of commonly mean it. But it's interesting to see how this area of law is increasingly being used by shareholders to attack the companies that they've invested in. Shareholders are increasingly saying, no, this isn't what I thought I was invested in, or I want certain standards to be upheld. And we're seeing that coming out in the litigation. And then as the sort of final example of this, what I wanted to just flag is a really interesting case that is coming up through the courts. This about Glencore's conduct and shareholders bringing claims against Glencore. So in 2022, Glencore was ordered to pay a 281 million fine following an investigation by the Serious Fraud Office that revealed that it had paid millions in bribes to gain preferential access to oil in Africa. Following a lengthy investigation and Glencore pleading guilty to several counts of bribery, this fine was imposed, and it's obviously very sort of damning and of Glencore's conduct. But what we've seen more recently off the back of that is litigation is now being brought by the company's shareholders against Glencore. So claims are being launched. It's reported that claims are being launched by nearly 200 funds with current holdings in Glencore of more than 3.7 billion. There's major city law firms acting for the funds in these kind of claims. We've got Quinn Emanuel, Palace Partners, Stewart's acting for claimants, and claims were issued in the High Court between October last year and spring this year, and particulars of claim have been filed. And so just to flag that this is something that we are seeing these tools in the Financial Services and Markets Act that are there to protect people investing in companies from misleading statements now being used in the context of misleading statements that relate to the use of natural resources and exploitation of communities and all that kind of thing. So really interesting to see, and it clearly is a growing trend. It's something that we should all be thinking about in sort of where things are going. So my reflections on where that leaves us, these kind of claims are difficult but possible. What's needed in order to bring these kind of claims is often financial losses, either to the company itself if you're trying to bring a derivative claim, or to shareholders, and that can be very difficult in where you're looking at, Shell, for instance, has had a record profits off of its behaviour, and so pointing to financial harm in these kind of situations is difficult. But as the kind of political landscape changes, as our outlook changes, as the climate emergency continues to get worse, that may be something that we see more and more of, the financial implications of these decisions that companies are making, and then that reverberating through litigation at a shareholder level.
Thanks very much.